Very good afternoon, everyone. Welcome to today's uLaw webinar. The topic for today's webinar is Law Office Matter Management, or Legal Office Matter Management, but the official title that you would put into your for CPD credits would be Law Office Matter Management. So today's webinar has been accredited for 1 hour of professionalism CPD credits in the provinces of Ontario, New Brunswick, and British Columbia. So for those who did ask about the LSO, absolutely yes. So today's webinar is accredited for 1 hour of professionalism credits. And please do log into your individual Law Society portals and use the title Law Office Matter Management. Okay. As always, like every other uLaw webinar that we have every Friday, today's webinar has this specific agenda. And we're going to primarily focus on the different steps that are involved in managing a file or a matter, if you were to call it. So the previous week, we had discussed about client management, the whole process of client intake, and the 9 yards of how you manage a client from an initial prospective situation to the entire life cycle of them working with your legal office till closure, and a lot of the documents that are involved, a lot of the compliance components that are involved, and so on and so forth. So today we wanted to cover kind of really the next logical subsection, if you will, of that entire life cycle management and focus it specifically on file management or matter management, and discuss the steps that you may want to take to either improvise in your current situation, learn to do something new, or if you've already been doing this in a very well formatted way, then of course we're just reiterating that you need to continue the good work. But we're going to talk about matter creation and steps, and a typical life cycle of a matter, which may differ based on the area of practice, the nature and the scope of the matter itself, right, and the type of client. And there are many factors that determine really the life cycle and the status of a matter. And we'll definitely dive into the compliance documents that are related to file management. So if you look at the 7 obligations of a legal practitioner, and as part of the compliance needs as a legal practitioner, we find a lot of compliance being and stress being put into the financial aspects of your compliance, and it still is a big priority for auditors as well as for legal firms to ensure that the numbers match and you have all your ledgers and journals intact, having generated your reconciliation statements on a monthly basis, and so on and so forth. Not taking away anything from that, but in terms of audit completedness and in terms of you being prepared for your audit readiness, there are a lot of compliance needs that the law societies talk about when it comes to how best you manage your files and matters. Okay. So I certainly have started the webinar, and I hope others can hear me. I would kindly request if you can dial into the phone number provided. If by any chance that the computer, that you're using the audio through the computer is bad, I hope the rest of you can hear me okay. And I would be more than happy to speak louder if I have to, but I'm really hoping you can dial in for a better audio. Alrighty. So when it comes to, of course, the compliance nature and how best to manage a file from cradle to grave, if you will, it starts off with, of course, the intake process that we discuss. It talks about the different important documents that you sign up as part of that agreement with this particular client. And each matter is an agreement by itself, even though it's for the same client. And of course, it's very straightforward, but often sometimes if you're doing this in a manual system, you may be tempted to pretty much have a single file for multiple work that you do for a single client. And that's one of the compliance aspects that the Law Society talks about, is to clearly demarcate or differentiate between different matters that you deal for a single client, even if it's the same client, right? So retainers, important documents such as receipts, and sometimes if the logical closure to the initiation of a matter is a non-engagement, then having the appropriate closure documents, the formal documents that you have signed, and having it signed by the other client party is very important to have a compliant, logical closure to that relationship, right? We, of course, then talk about what's been discussed and put on paper with regards to how you want to manage. Okay, so actually the dial-in number is right here on the phone, in the chat window that I provided. If you just scroll up, you would find it. Okay, so we'll talk about how best you can manage these different matters. I would sincerely appreciate if you could turn off your cameras, those who do have it on. Greatly appreciate it. And as part of the whole matter management, of course, we talk about the financial obligations that both you and the client has in that working relationship, right? Whether it's trust-based, general-based. I'll pause for a real quick second. I do have a few participants on the call who do have their cameras on. It's a very simple button to turn off the cameras, if you can be kind enough to do so. Okay, give me 1 second, please. Awesome. So going back to the agenda, we talk, of course, about the actual engagement itself that's been written on the retainer letter. We talk about trust, general management, the important steps that you have to take within that file that fundamentally reflects the financials that you then have to reflect within your ledgers and journals. Because what you do within the matters, what you do within the file, and the financial aspects are just part of that transaction encapsulation, right? You don't have a trust money coming in randomly. You have trust money coming in on behalf of a client for a specific matter. So that entry of money coming into your trust account pertains to a specific matter, file number, and it's in that context. And hence, it's very important that the steps that you take and how you manage that transaction within the context of that matter is done in a normal, compliant manner. Okay. We certainly will talk about mobile docketing and the tools and technologies that you have in today's day and context. And this is something that's been available with uLaw, and I'm sure it's available with other legal accounting softwares or other practice management softwares. They become very important pre-COVID and post-COVID. Even though we're at home, we're very much in front of devices. One of the things we're seeing as legal offices, both solo practitioners and with small to medium large firms, we as consumers tend to be more on our mobile devices rather than on PCs and laptops. So a small subsection of today's webinar will talk about the benefits, of course, and it's left to you and your convenience of whether you want to use that or not, right? And last but not the least, we'll talk about the analytics that gives you a better handle for the data behind driving these files and matters, allowing you to make better decisions in terms of the types of files that you as a legal firm want to manage and maintain. Okay. We spoke about the professional obligations. We spoke about the client intake kind of being that first step. We've discussed this in our previous webinars, and you should be able to browse through our YouTube channel, and client intake is still a big part of that process. Okay. I hope you're able to see my screen. Today seems to be that one of those days where you don't have access to internet, and hopefully this helps. Alrighty, so from a client intake process, we discussed this last week. I don't want to dwell too much into the specific aspect of it, but it's important that as you intake that client, as you initiate that matter management component, that you start with a detailed recording of the call and the consultation. We discussed that. You determine all the right steps to see if this prospective client is right for your firm by doing the conflict checking for confidential information. And then you determine the collateral for fees depending on the nature of the work that you entail doing with this client, whether it's a family matter or a accident benefits, a criminal, small claims, depending on the nature of the matter itself. You would now determine, based on your experience, based on what you know, the different rules and regulations of that matter management, starting with that retainer letter, right? The retainer letter is a fundamental document that everybody goes back to, especially when there's conflict. And hence, if there's one document that you want to spend a lot of time on reviewing and updating, making it sharper, crisper, easier to read, covers your responsibilities and covers the responsibilities of your client, ensures that both parties are held prudent to what they're required to do, this is one document. And it's that same document that highlights the fee structure, the retainer structure, if there is one, and if there isn't one, then what are the terms and conditions for payment of fees, right? So we've discussed this before, and all this comes as part of that matter management. Whether you do this in a manual basis, whether you use an Excel sheet and a Word document to do this, and that's fine. Whether you use a legal accounting or any other system to do this, it's very important that you have well-drafted retainer letters and follow what's been agreed upon in that document through the life cycle of that matter. Okay? And as we discussed before, the whole financial ledgering comes from the context of the matter. So when you're depositing a retainer into your trust account, and that gets ledgered in the back end, of course, as an entry into your trust ledger, right? As the data entry of money coming in. But what's important for you to note is in that ledger, it clearly asks you to understand and highlight the client and file number or the context in which you received that amount. So the retainer is just not a random number that's sitting in your bank. It should have a certain specific context to why it's even there. Okay? And the last step that I see here, and I wanted to cover this real quick, is the non-engagement of it. So you've done all the due diligence, right? You've actually done your client intake. You've done your conflict check. And let's even assume that you move forward with creating a matter or a file. Okay? But at some point in time, for whatever reason, if you and your client needs to non-engage, for whatever reason, you do need that exit clause. Like every agreement has a certain exit clause. The non-engagement letter and the rules around non-engagement is that such exit clause. So if you do have that, and once again, review your engagement/retainer letter as the rules that govern that non-engagement clause. And let's assume that you or the client has decided to non-engage. This is one other thing that we find within audits that the auditors ask for is show me a non-engagement letter, especially if you have non-engaged with that client. Often people generate it at the last minute. What we recommend and stress upon is just to bring a logical closure to that particular matter and to save you time and grief, to not having to revisit it at a later time. generate the non-engagement letter, have a specific template available written, or if you're using legal accounting software, those softwares give you the templates that you can repurpose. Have those templates available readily so that you can quickly fill that form, sign it, and have it signed by the client. Okay? So let's say you've done all the good work. You've taken the client intake and you've proceeded with writing a very clear-cut retainer agreement or an engagement letter agreement. You've signed it, assuming that you've got a retainer as part of that engagement, providing the retainer receipt. Very important. So maybe a document that's equally important after the retainer agreement is the retainer receipt that clearly states the amount received, from who it was received, when it was received, how was it paid for, and the client and the matter for which it was transacted. So, right? The retainer receipt is an important compliance document. So once again, a checkpoint on a compliance document when it comes to matter management is that retainer receipt. Now we move on to the next phase of running this matter or working on this matter. Okay? When it comes to the obligations that the Law Society talks about in how you manage this matter, the first fundamental step that the Law Society talks about is having a certain file organization concept within that firm. Ensuring that your files or matters, and I'm going to use these terms in synchrony here, they are unique, which means if you have a file number, that you have a unique way of earmarking each matter with a unique reference number. Okay? Even if it's for the single client and you have multiple matters, each matter needs to be unique. You can come up with your own numbering system. Certain systems that you use may have their own numbering systems that you need to be okay with and at least understand how it's created. And the reason for the uniqueness is because each and every transaction needs to be clearly marked against the context for which that payment was made. Right? If you've got $1,000 for the same file, 2021,000, it's going to be misleading when you're doing a reconciliation as to which matter are you going to apply this for, and hence pretty straightforward as to why this needs to be unique. The second important aspect of that file organization is it's cross-indexed. And what does cross-indexed mean is that you're able to quickly, easily do a conflict search the next time a Jerry Jones shows up. And if you have a previous Jerry Jones and all of the matters that you've created for Jerry Jones, that you can quickly search against all of your old files, and for a system, both manual or automated, to be able to help you make an informed decision around the conflict search. So not only should that file be unique, it should be organized or set up in a way that you can easily cross-index that file when you're doing your conflict search. Okay, so that's one of the first things that the Law Society talks about when you're establishing a system to manage your matters. The second aspect that closely follows the retainer or engagement letter that the Law Society talks about is follow the retainer or engagement letter when it comes to billing and when it comes to dispersing. And the third aspect of that, the natural third component of that, is the invoicing. Right? So you've got a matter now, you've done all the due diligence, you're clear to work on this file for this client, you've signed a retainer agreement, and hopefully that's well thought through, and you know how you're going to handle the work that you're going to put in towards that file, whether it's yourself, a combination of other colleagues in the firm who are going to help you through that file management or executing the file, whether that's meetings, whether that's discussions, court visits, whatever the steps may be. Filing if it's an immigration file, doing all the right steps to file that particular client's application, right? Complete final closure of a specific file. So there's many different workflow steps. If it's real estate, then of course you have so many well-drafted, well-determined steps that you pretty much repeat, rinse and repeat for each client, right? So each and every matter has its own workflow steps, and you as the legal firm determine the rules around the billing, the dispersing, and of course the docketing that comes along with the billing. So this is the third aspect after file organization and cross-index that the Law Society talks about, and it needs to be very much in adherence to the engagement or retainer letter. Okay? And the last aspect the Law Society stresses upon is ensuring that you're doing everything possible, either through training or a combination of training, process upgradations, discussions, personal discipline, to update the status of a matter on a regular basis. There's two reasons that the Law Society talks about when it comes to updating the status of a matter. One, of course, for compliance. So if you have a matter that's outstanding with the last modified date being, let's say, 10 years back, then there are certain regulations that, especially if you have outstanding retainer amounts sitting as trust listing for that client and you've not worked on that file for many years, then you do have a certain obligation to refund that retainer back to the client. So updating the status of a matter becomes very important so that you're up to date both with respect to that file, but also for you to make the money with regards to that file. And if that file is not moving any further, then you make a determination of whether you want to, again, non-engage, refund retainer, whatever logical steps that you have to take to push that file towards the next step. The second reason why the Law Society talks about updating the status is ensuring that you as a legal firm or a legal practitioner have your eyes and focus on all of the open matters at any given time. So updating the status of a matter from open to closed or archived or any other status name or nomenclature that you want to provide is totally fine. But again, clearly categorizing these matters based on the status gives you the perspective of focus to work on the open files and use the open or the closed or the archived files more from a reference standpoint. Okay? And we're going to, of course, look a little bit more deeper into file management, but I've already discussed the two major aspects that we often see when it comes to audit, working with our clients, where they're very successful through these questions. One is, of course, having a unique number for these files, having them separated out, even if for same client that you have multiple matters, being able to easily cross-index the search of these, not only files, but the data behind the file. And that's what we talk about. So if there's a Jerry Jones with the file 123, the next time a Jerry Jones shows up and you do a conflict search, then your system should be able to tell you that previously you had a Jerry Jones and you've also created a matter number 123, which is a criminal matter, so that you can do a deeper dive and have a better determination whether that second Jerry Jones is a conflict or not. Right? Pretty straightforward. I know I'm preaching to the choir many times when I talk about these very simple things. So as long as you manage those two very important components, then you should be good. We talk about the retainer agreement, and this is something we've discussed in many of our webinars. Everything that you do within that matter and every financial transaction that then enters into your bank or financial system that needs to be converted into ledgers and journals all start here. The retainer or the engagement letter. Okay? Because we talk about the nature and scope of matter, the responsibilities of the client, so paying me on time, corresponding with my firm on time, right? Giving me the right appropriate steps if needed on time. The scheduling and course of representation from your office's standpoint, the frequency of communication, and even the method. Given today's day and age, we talk about electronic communication kind of being the primary mode of communication. Some law firms also have the confidentiality notice, something similar, which talks about the risks and rewards of these types of correspondences, right? And the last thing that we often talk about is the financial agreement with regards to this matter. What is the retainer? What's the retainer top-up cycle? If it's not a retainer, or let's continue with that retainer. If it's a top-up, then how often? How often do you plan to generate an invoice? Are disbursements included? What's your fee structure look like? What's your per hour billing cycle? Or if this is a flat fee, what is the cost? Or if it's just an agreement that it's per hour and you're going to be charging by the hour, what that billable hour rate looks like. Because based on what you sign and signed by your client is how you actually operate on this file. So maybe I have stressed this a little bit too hard, but just reiterating that the retainer or engagement letter, whichever is pertaining to your situation, is critical. And we discussed this maybe a couple of webinars prior to this, which talks about disbursements, or maybe it was my last webinar, talking about disbursements demystified. We talked about the ability for you as a legal firm to disperse, which are really expenses that you incur on behalf of a client and a client matter, the different ways in which you can actually disperse, both from your trust account if you have a retainer involved, or from your general account with or without a retainer involved. General thumb rule that if you're actually doing it on actuals, then both trust and general are good financial vehicles to disperse out of. But if you're looking to do either a profit or a loss margin, or if you see that as part of the transaction, then predominantly consider a general account to use for disbursements. So paying out of the general account for disbursements and then recovering through that invoice. But how often do you recover is again determined by your retainer or engagement letter. Fantastic. So let's assume that you've done all the right things, right from client intake to the life cycle of that matter management. You've docketed on time, dispersed, invoiced, and hopefully you've recovered on time. Here's a quick list of some of the important compliance documents that the law societies across Canada look for during an audit within a client and matter management. Okay, so within that matter management and as part of the overall client relationship management, if you will, the law society may ask you for you to showcase any proof, photocopies of any client ID documents that she or he may have provided you or they may have provided you in terms of corporation before and why you determine that this is truly them, right? So simple client ID. The Law Society also has what's called as a client ID verification form. It's available for LSO within the Law Society's websites and similarly so in the other provinces. With the uLaw, we have that very much within our product, but it's a form that's readily available for you to download and fill out. And that form gives you the opportunity to clearly articulate as the information that you received from the client. You've got their driver's license, you've got their passport, and you've determined that there's no conflict because you've done the due diligence, and that's you validating back to the Law Society that you've done the right things, the right steps to determine that this is an important client that you want to work with. Closely followed by that client intake or client ID verification document, the Law Society would definitely like to review your retainer or engagement letter. For that file, they may choose a random matter and ask you to showcase all of the documents that you did have or produce as part of that life cycle of managing that matter. And if you do have a retainer agreement, then clearly they're looking for retainer receipts for every retainer entry that you received. So if you've got 3 top-ups after that initial retainer, they're looking for 4 retainer receipts, or at least retainer receipts that match the total amount received. Okay? Conflict checks and any conflict resolution documentation. This is important. So in some cases, in some very rare cases, you may understand that there is a conflict, but maybe you are able to articulate as to how you want to mitigate that risk of that conflict, and you may submit a resolution documentation as part of your agreement of working with this client, knowing that there's a conflict. Right? For matters both where you've done the client intake, created a file, sometimes you may have non-engagement letters for ghost clients. Ghost clients are those who pretty much come in, flirted with the idea of engaging with your firm, giving you some pertinent information, and then disappeared. Let's say you have created a matter. You certainly want to have a non-engagement letter that talks to that. Talks about the life cycle. This person came in on this day. They gave me all their information. They said they're going to send me a retainer, but never showed up after which, and hence you have a non-engagement letter that states, I or my firm hereafter is not responsible for representing you and this particular matter. Right? And that's clearly what the non-engagement talks about. It frees you and your firm of the responsibility of working with that client and the client's matter of interest. In some cases, what we've seen is with the audit, they may actually ask for the invoices, the template themselves, and the frequency of the invoice. In some cases, you may be asked to show a bill of cost. In some cases, statement of trust and general accounts for that particular matter. I'm not talking for the entire firm. We're talking about specifically for a file. And we'll also talk about some of the other documents that the law societies may request depending on the tenure of the matter itself. So if this is an ongoing matter, then a quarterly update to the client, and a very common document of that is the statement of activity. So what's happened in those 3 months, the different steps, ins and outs out of that matter. That's represented clearly and very well articulated in the statement of activity, which is, again, these are templates that are very much available to you to review and templatize it for your own benefit and your firm's benefit. Bill of cost and summary, depending on the nature of the matter, the type of client. If there's a corporate client, then these are something we see. If these are legal aid matters, then you have the statement of activity to showcase the work put in. And if this matter is ongoing beyond a year, then of course a statement of accounts of both the trust and general, if involved, is really not a must to have, but it's really nice to have to showcase that you are staying very much as prudent as you should with regards to the client's money that you have in your trust, and how best you've used those funds and how best you've drawn out of those funds. Right? Because we often hear from the public, and we've seen cases where trust money is misappropriated, and this pretty much leads to these checks and balances to ensure that knowingly or unknowingly that you're not making the mistake of misappropriating, especially trust money. And something we stress upon here at uLaw is always have a logical closure to a matter before you change the status of that matter, which is through that final closure letter, a thank you, a summary, a specific thank you card that you send, whatever it may be, but having a document that clearly states that this is when you started this matter, you've done the work, and as of this date, and that date is very important, you tell that this matter is done, and just similar to a non-engagement letter, you're drawing a closure saying you and your firm would not be responsible for anything regarding this file. If you are to be, then here are the rules and regulations, boundaries of engagement. Right? When you close the status or change the status from open to closed or whatever you feel fit, keeping those files, every document that you've generated, having them readily available right within the context of that matter, so you review it when the day comes to audit. So right from client ID verification to closure letter, these are some of the documents that a law society may ask you for when they want to review your compliance or file management compliance for a matter. Okay. There's a question about, this particular webinar, I repeat, is accredited for 1 hour of professionalism CPD credits in the provinces of Ontario, British Columbia, and New Brunswick. And the title for the matter, or for this particular webinar, rather, is Law Office Matter Management. It's available in our chat as well, so you can copy that. And it is being recorded and will be available for you to review on our YouTube channel as early as Monday next week. So if you have missed the first 15-20 minutes of this webinar, you can always replay the entire hour and claim your 1 hour of CPD credits. Now we have, when it comes to managing time, of course there's the component of your legal office, your individual time of managing time across clients, across matters, across other things that you have to do to keep the lights on to run your business. But when it comes to the frequency of how often to touch base with the client, this is a very tricky question that's often asked, and is something that's part of matter management too. There has to be a context for you to reach out to your client. Again, hopefully it's well articulated within that engagement letter or retainer letter. Right? You would reach out to them when you have doubts or you need clarity. You reach out to them when you want to communicate a certain schedule or course of representation. You reach out to your client through an invoice. You reach out to your client through receipts for payments. There's always a reason for correspondence. But law societies talk about certain recommendations, and especially for matters that extend beyond maybe a few months, right? And talk about the importance of a quarterly review with your client, just to quickly go through what's happened, what's happening, and what's to happen next. If it's beyond a year, some criminal matters we've seen with our clients are ongoing. Sometimes it's over a year. Then, as we discussed in our previous slide, sending them a statement of accounts, whoever you're dealing with on the client side, with both the trust and general accounts clearly defined. Because that gives your client the confidence that you as a legal firm are working for the benefit of closure and a logical good closure to that matter, but you're also dealing with the finances in a very candid, prudent way. Okay? Again, as I mentioned, this is a recorded webinar, so I'm going to leave the slide open real quick. But here are some examples of documents that, again, I'm not reiterating myself, but just a quick glance at certain documents that are important for you to correspond back to a client. So you've got that initial retainer engagement letter, followed by clear and crisp invoices and receipts for payments received, statement of activities, bill of cost, sometimes client fee book, which talks about the chronological set of transactions that have occurred with regards to that client across matters. So the client fee book is something, let's say you have multiple matters with that client, a fee book clearly articulates the fee received across matters. So each and every matter is a subcategory of that document. Now, it's also important that sometimes when the clients don't pay you on time, that you send them a little nudge, a little notification. Don't wait till the 30 days are over to charge them an interest. Let them know ahead of time that they're needed to pay this within the next 10 days. If not, as per the agreement, this is what's going to happen. That helps. Sometimes if you have payments that are outstanding for a long time, then sending them a aging report helps to recover for those unpaid invoices. We find that often within corporate engagements of our clients. And of course, closure statements are that final document to bring a closure to that matter. You may have multiple matters where one matter is closed with that client. You may have multiple other matters that are still open, but you bring a closure to the context of that file or matter. Okay? Alrighty, so we take a quick segue with another 10 to 15 minutes remaining in today's webinar. Again, reiterating for those who just joined us, the title for today's CPD webinar is Law Office Matter Management. Okay? So that's the title that you would enter within your Law Society portals. And as part of the agenda, we talked about the different steps that you take prior to creating a matter, part of that client intake, ensuring conflict. The expectations from the Law Society when it comes to how you manage a matter and the life cycle and the status of that matter. We've discussed how best to manage correspondences with the clients, different documents that you would maintain as part of managing that file or matter, starting with that retainer or engagement letter till the closure letter that you send out to your client. The Law Society's requirements as part of that matter management, right from having unique file numbers to cross-index, the ability for you to have the pertinent non-engagement letters, the timely set of documents that you need to send to your client. And we've discussed how the whole concept of trust general management and the finances that enter into your financial system that then get converted into financial accounting documents that do have compliance as part of them, they all start with this matter as the context. A retainer is received in the context of a file. Payments are received in context to a matter. And it's important that you have a clear separation of matters, even if it's for the same client. Okay? So please do use the chat window, and I like to make this as opposite of a monologue as much as possible. So if you have any questions so far, I'm more than happy to talk about my experience of having dealt with this now for almost 14 years. And we take a quick segue into talking about additional parties. And this is critical in certain areas of practice. They're more important in certain areas of practices, not so important in certain areas of practices. So if you're talking about a family law matter, of course, it's very important for you to appreciate all the parties that are involved. If it's a criminal matter, it's important for the law society to know, as well as you and your client to understand the different parties, especially for your legal firm to know the different parties involved. And the reason, one of the fundamental reasons, as you may already know, as to why we capture these parties involved, is to also help solidify the whole conflict search database, right? So if you have certain individuals who have been party to this matter, and they may have played many different roles, defendants, representatives, right? Depending on the type of matter, landlord, tenant, applicant, with plaintiff. You could have parties even such as police officers, health practitioners when it comes to accident forms and accident matters. And all these different parties are part of that matter management, a totally different aspect of that life cycle which we did not cover from the client intake to closure, was this aspect of the other parties that are involved sometimes as part of managing those matters. And when it comes to documentation, as part of compliance, but more in terms of operational convenience, and it's important for you to have these court forms filled out. Right? Each and every matter, whether it's a plaintiff's claim, a defendant's claim, if it's a divorce matter or file, if it's a divorce form, if it's an 8A, there are different types of court forms that allows you to capture information about that file, about all the parties involved in that file. They want you to clearly split it out, mostly containing names, addresses, relationships, other legal representatives who are involved. And if it comes to family, you may of course have monies involved, right? So something for you to think about is, in your current matter management strategy, how do you ensure that you're able to capture all these different parties that may be involved as you execute and manage the matter? And how do you make it easy on yourself to be able to do a comprehensive conflict search the next time a Jerry Jones shows up? Maybe you had a Jerry Jones for whom you did a matter. You could have had a Jerry Jones who was a different party involved in a totally different matter. Maybe you did not create a matter for Jerry Jones, but Jerry Jones was a witness in a totally different matter that you worked on. But that name Jerry Jones needs to be documented, and it should help you resonate and make a more meaningful decision on the conflict. Another operational convenience or inconvenience, if you however you look at it, or important operational step that you are most necessarily required to take is fill out these court forms. Whether you do it, and again, Each court form is available to you on the individual Law Society websites that have these court forms. You download them. Some of them are in Word documents. Some of them are in PDF. We at uLaw, for example, specifically for the province of Ontario, are able to pre-populate many of these forms as we try and keep them as close to the updates that are often made. So some of the more recent updates that were made to the court forms in Ontario are now readily available in the uLaw system. And what we enable is, of course, the automation of these court forms based on the information that we've captured one time. The minute you have additional parties involved, the different sections in which that information needs to be filled out happens pretty much automatically through that. Likewise, as part of managing that matter, as part of optimizing your time to manage matters, and as part of that conflict search criticality, please do ensure that you have a strategy, you have a certain process of how to capture these additional parties, record them in the context of a matter, and be able to retrieve that information both in terms of court forms as well as conflict search databases for your convenience. Okay. Now, this last section that I want to talk about matter analytics, is more for the legal firm. It's not so much the compliance, but it's more for the legal firm, the owner, the firm themselves, to have a better handle and better insight to the nature of the types of matters that your firms are involved in. And this is very critical whether you are a brand new firm that's looking to start and establish your cadence, or if it's a known firm that has been in business for a while, whether you're trying to rebrand yourself, expand your horizons into newer territories, be able to, whether that's geographical territories or whether it's new areas of practices. We all make decisions based on the knowns, based on past experiences, which is nothing but a recording of certain transactions. Often the experiences are recorded in our memory, which we're able to retrieve. When it pertains to science and when it pertains to making decisions based on data, a legal firm in today's day and context needs to truly have a strategy in place to not only capture matter-related information, but have the right systems and or the people involved to give you the insights about the underlying facts, trends, microtrends that empower you as a business owner to make the right, positive, impactful decisions towards productivity and profitability for your business. I'll probably take a quick break, probably one of the longest English sentences that I've ever made in my life. But I hope I made sense. It's not important if you just execute matters. It's important that you're able to gain information to apply on your experiences to make the right decisions for the future. For example, if you don't capture and if you don't draw the analytics and the insights on the profit and loss on a specific area of practice, let's assume for whatever reason you constantly see a little loss in the work that you're doing in the overall business, and maybe that's because of a certain area of practice that's new to a certain area of practice that a new colleague has brought in, or maybe just a trend around the type of billing that you're doing for a certain area of practice that's pulling your profitability down. Unless you have the right systems that gives you the insights to make decisions on, then you're going to just continue to make those mistakes, continue to work on those areas of practices without recognizing the negative impact that it has on your bottom line. So Matter Analytics is a combination of many things, right from the type of client, whether it's a individual or corporate client. Sometimes you may determine which type of client is the best bang for your buck as a business. Let's say you're only working with individual clients, or let's say you're only working with corporate clients, then you have subcategories and you need analytics for that. So if you're a lawyer or a legal representative for corporate clients, then you further create subcategories under the overall areas of practice. This could be corporate Peel region, corporate Vaughan, or it could be corporate Ontario, corporate Quebec. Now you can start to see analytics and trends in these subcategories. Or if it's an individual client that you deal with, and maybe you're really good at 3 areas of practices, right? Family, criminal, small claims. Now starting to see trends, and hopefully upward trends towards which areas of practices give you more profitability, lesser time spent, more revenue recognized, days on sale, so you can understand the trends around days on sale, which is which customers paid you the fastest. Where were you able to retrieve money faster or recover expenses faster? So there's just so much of data and insight that's hidden in the data that you're collecting as just part of executing these matters, and put those data components into play by having the right systems that can transform the data into information, and certain systems that can transform that information into easy, consumable dashboards and insights. Right? And of course, I said I'll spend the last few minutes on talking about the whole concept of mobile docketing. The legal practitioner today, again, we have the COVID situation and hence very much at home, and we have the lockdowns. But hopefully soon, once the vaccinations have kicked in, once we start going back to a bit of that new normal, you're going to start to see the same pain points that busy professionals had before, which is having to be on the move, having to have information on your fingertips, having to be that mobile-first consumer, being able to withdraw information across devices. And you're starting to see legal systems that support and are the backbone and sometimes the toolkits that help you and empower you to do these things. You're going to start seeing a big trend of enablement towards mobile technologies. And if you've not already seen it, you're certainly going to see that more obviously in the next few months and the years to come. Whether it's docketing conversations on the phone, converting conversations into automatic dockets, creating client intakes right in the phone, even getting to the point of billing on the phone. You're going to start to see trends that help you do that. All we're saying is be ready for this. Be ready and prepared to take advantage of the situation and put this technology to use so that you can reduce the operational time that you're putting in. So the question often is, oh, great, it's mobile technology, but how is that going to help me earn business? There's not a direct correlation to these things, but the more and more you consume technology to make your lives easier, the hope is you can make technology work for you to make your clients' lives easier, making client intake mobile friendly. So the next time someone's on your website and asks you for information, sending them an email that they can download on their phone, quickly sign that right through that mobile phone and send you back the client intake form. That's now enabled you to be mobile friendly, powered by mobile, and it's that consumer base that you're tapping into as well, right? You're starting to see mobile payments being made. So legal offices are now able to send out invoices, simple links being sent out to clients so that the clients make those payments easier. How does that mean anything to you? It means faster recovery of revenue, right? So not only do you want to put yourself in the shoes of a consumer and the ease with which they're able to transact and work with you, we often talk about that in our BX, CX, UX, PX webinar. So this is all about the comfort and the customer experience and the overall user experience. So first, be a consumer of the modern great ways in which you're able to do your work, reduce the amount of operational time put in so that you can spend more time on strategy, on marketing, helping grow the brand awareness of your business, partnerships, bringing leads to your business, putting the operational systems at least to a semi-automated situation where you can reduce the amount of manual effort put in and save that time and money and effort towards money-making tasks. And then translating that mobile experience to delivering it to your consumers and your clients so that you stay abreast of technology and take advantage of that new consumer base that are used to dealing with businesses mobile first. Okay? And talking about systems in play, if you're using a manual system today based on a bit of research, we recommend that you look into having a system in place that can help reduce the manual effort. And during that research, do search up this term, legal accounting, because in the provinces of Ontario or in the cross provinces in Canada, legal practitioners are being audited. Legal compliance and audit is a big part of our culture and the legal community across the country. And hence, legal accounting, which was purpose-built to manage compliance for practitioners and law offices, hopefully based on comparisons that you make with regards to cost, convenience, training, ease of understanding. There's many factors that are personal to you. Make that judgment, but do make it part of your search, and that's our kind request and recommendation. And that's pretty much all I wanted to talk about really in terms of matter management. And I would keep the floors open for any questions that you may have at this particular time pertaining to today's webinar. And of course, if you have any questions regarding our company, uLawPractice, we've been in the business of legal accounting, practice management, business accounting, serving thousands of practitioners now over the last 12 years across the country. And we'll be more than happy to walk you through what that experience looks like if you visit our website at uLawPractice.com or uLaw.io. I'm going to open the floors for any questions the participants may have pertaining to today's webinar about matter management. And the most often question was the title. It's Law Office Matter Management for 1 hour of professionalism CPD credits in the provinces of Ontario, New Brunswick, and British Columbia. So the question around, yes, this particular webinar is being recorded, and it should be available on our YouTube channel. So the YouTube channel is youtube.com/uLawPractice. I'll put that on the chat as well. So there's a question around previous CPD webinars. So yes, we do conduct CPD sessions, at least 10 to 12 in a year, right? And all of them are professionalism credits. We are trying to work on certain substantial topics in the coming months, but today, whatever webinars we've conducted, they're all available on our YouTube channel. In terms of the documents being forwarded, so you do certainly have today's video being recorded. If you are an existing client of uLawPractice, then of course you have all of the documents, right, from compliance to Law Society compliance, and the whole thing in our help that not only talks to you about the product, but we advocate the need to be compliant and the steps that you can take to be compliant. So that's definitely part of the whole program. So you don't have to necessarily respond back. In the past, we were being audited by the law societies to ask if participants had participated in these webinars. But today, because of our YouTube convenience, you are able to view the entire 1 hour of our YouTube channels of these different topics and be able to claim the 1 hour. So all you have to do to claim the 1 hour of professionalism credits is type in Law Office Matter Management and then put 1 hour against that. And of course, there's a leap of faith here that you've covered these topics and you've understood what was discussed in these topics. So the quick answer is, yeah, you don't have to respond back to us if you don't want to. Sometimes people just use it as a bookmark to send us an email saying we were here, and then they're always able to recover it at a later time. But you don't have to if you don't want to. So let me stop the recording and take any more questions after that.